Okay, well, it's another time for a little discussion on litigation. We were talking earlier about oral depositions, and so consider this to be part 2 of depositions. You find it in Chapter 9. One of the things I want to emphasize on this that you'll see in your session is cost. Depositions are very expensive. The thing is that the court reporter is separate from the other proceedings in the court. A lot of times these are even private court reporters, and again in Indiana only requirement is notary public. So you can hire somebody to come in, but their time is worth money, and the time spent in the formal deposition itself is only part of the time that they're spending, because they have to convert everything that's said in that room into a formal document that can be admitted in court, and then they have to certify using their notary seal that everything that was said in there is accurate. So that's a very important point, is the cost. Now, like I said before, in some of these smaller counties, they work out agreements where the notary that works in a certain lawyer's office is going to handle the deposition at no extra cost. Problem you can get into that is they might word things in a certain way. You've got to be a little more on your toes as far as reading through it to make sure that it actually says what the witness said. Not saying that they're going to try to cheat you, but they're kind of partial to the person they work for, and sometimes that can be a problem. So very important. Rule 27 to 32 in the Indiana trial rules are critically important in this area, and also 33 through 37 deal with other forms of discovery. Later on down the line we're going to stress the interrogatories. That's the way this is all set up. I personally would flip it and put the interrogatories in front of the depositions, because many times I've seen where interrogatories are sent out first, then the deposition is scheduled after the interrogatories, because you find out a lot of information through the interrogatories and then you want to fill in the gaps with the deposition. Also, Rule 30B requires that the person be given notice of the deposition. Now, this is an area that I want to talk to you about, because I'll tell you, big city firms have just come in and noticed a deposition to be held at their office in, say, Indianapolis or Fort Wayne without my permission. Now, the person is allowed to insist that you take their deposition in the city where they live, and a lot of times I would say, hey, we're not going to appear for a deposition unless we have it in my office or in my town. It could be in the courthouse, a neutral place, or it could be in the plaintiff's office if the defendant is trying to schedule. But you want to make enemies all over the state, just start noticing depositions without consulting the opposing attorney. That is a very bad practice. I've seen lawyers do it, especially young lawyers in Indianapolis and Fort Wayne, and it's a way to make a mortal enemy of a small town lawyer, and you don't really want to do that. It just makes your life really hard. So if you're working as a paralegal, try to gently advise that you use a more consultative, collaborative approach. The courts want you to do that. They want you to cooperate in discovery, and so that's a good way to go. Is just get together on the phone, talk it over. What's good for you? Well, that works for me. Your place or mine. Come to my place. I'll provide the pizza. Seriously, just be a good host if someone comes in, and it'll go a long way in the future, being able to work together. And what your real goal is to work out a good result for your client, whether it's a plaintiff or a defendant. Okay. Another thing to consider is the subpoena. Usually if you send out a notice of a deposition, you want to include a subpoena, and subpoenas are handled under Rule 45D. So very important. Now another type of subpoena to consider too is that subpoena ducis tecum, which is Latin, and it means bring the papers, okay? Bring the document, bring anything that's vital. So you want to, on the subpoena itself, spell out what you want. So it'd say ducis tecum, all records pertaining to this case. Now that's pretty broad and sweeping. They pull up in a great big old semi-truck out in front of your office. I don't think your attorney's going to be very happy. So try to narrow it down. Medical bills, lost wages, you know, evidence of any wrongdoing by the defendant, you know, whatever you want to specify. Narrow it down, put it right on the subpoena in a short statement. Another thing, criminal cases, a lot of times public defenders don't have any money for depositions. So that's where you have to be kind of creative. It's a funny thing, I used a camera like the one I'm using right now, only except it was about 10 times bigger and weighed about, 20 pounds, you know. This one here, I've got one right here in my pocket. These are the coolest little things. This is called a flip camera, and you know, very easy to operate. I've got it set on a small tripod, and so, you know, things have come a long way. And it cost me $100, and it works great. I think you'll agree. The picture on YouTube is fantastic. The ones I used to get was a Sony, which was supposed to be your best quality. Cost me $1,000, and I had to lug it all around the countryside to take videos with a much bigger, stronger tripod so it wouldn't fall over on me. So times have changed, we've come a long way. So these little you know, flip cameras are a good way to go. What I did then with that flip camera, I would save that into a MP4, and then I would send that to a court reporter and have her transcribe it. So you save a lot of the cost in terms of having her have to travel clear to Denver with me to take a deposition in a criminal case. Now once again, you have to get agreement from opposing counsel, but this can be a real cost-saving tool, especially prosecutors. They don't usually care if you want to go that route, because they're going to be sitting there, they're going to be able to say, well, yeah, that's what happened on the video. So you can provide them a copy of the video, you provide the court reporter with a copy of the video, they transcribe it into a document. That's going to cost some money, but probably about 50% cheaper than having to drag them around within Indiana, and it's a lot cheaper than having to drag them out of the state. So very important consideration. Okay, another thing is people have the right to review the actual printed transcript of the deposition and make changes. Now that does happen. People will say things like they'll make admissions in the deposition, and then they'll want to change those later and say, well, I misspoke, I didn't really mean to say that, when their lawyer gets them aside and says, what, do you realize what you just said, you know? That's one where you'd have to go to court, I'd say, to try to sort that out, because if it changes the whole meaning of the deposition, that's a lot different than, you know, where the court reporter did make a mistake and mishear or misunderstand. And that's where having your paralegal with you when you're taking the deposition, taking her own notes, could be vitally important, because you might end up having to be a witness for one side or the other, that no, he said this, the court reporter heard it wrong, and so you can change those accidental typographical errors. But if it's something that's going to change the whole meaning of the deposition, then that's going to require an objection. It's going to have to require a court hearing, you know, to completely change it from black to white. You don't see that very often. Well, okay, so changing, modifying, correcting is according to Rule 30E, so you can do that very easily. And then the final product is sent out to all sides. And it's important about depositions because they can come back to haunt you if a witness does a really bad job on a deposition. So if you're involved in witness prep, make sure they understand how important that is. Sad to say, but I've actually had clients show up intoxicated for their, and that's happened to me twice, showed up intoxicated for a deposition. It totally ruins the case because they make a record of that, they submit that to the trial court. Trial court a lot of times will grant summary judgment just on that basis alone because the client has no credibility. Both of these cases were tort cases. The client injured in a parking lot in one case. Client was fired in another case for being intoxicated on the job. So what's he do? Shows up intoxicated for his deposition. So, you know, those are just terrible circumstances. And, you know, if I had that all do over again, probably would have been able to cut that off at the pass, figure something out. But I had no idea that that was going to happen. So it's not a good idea to have clients show up unprepared, whether it's intoxicated or just answer questions incorrectly. Then you have to try to salvage something where they misstated something and they didn't really mean it, but it just causes a whole big problem. Well, important thing to understand as a paralegal, you may not be required to have any role in depositions. You may be involved in preparing the documents. Like I said, as you get more entrenched in that firm, they may start giving you more and more responsibility regarding depositions, like preparing questions, preparing the witness, and so forth, so that the attorney just walks in, you hand him the questions that you prepared, the attorney goes through, asks those questions, may augment it with a couple more of his own, everybody's done, everybody's out of there, and you know, it was a very valuable part that the paralegal played. Important emphasis in your lecture notes is that as you work in a firm longer, you develop more trust, they give you more responsibility for things like this. So you want to be thinking about the future in terms of what role you'll play as a paralegal in the preparation and conducting of depositions. Frankly, like I've said before, some of the best work I ever did in jury trials was where I had that paralegal right behind me across the bar handing me the things, anticipating, well, you need to do this, you know, cross-examination, ask these questions. Already well prepared in advance, you know, where we've almost even role-played our way through it. You do this, then I'll ask these questions. If I forget anything, you know, motion me over and I'll lean over the bar and you can tell me what I forgot. Great. I had a great trial where I had a really good paralegal really helped me in that situation. So the part of the, I can't overstate the part of the paralegal in the actual courtroom. Now you're not going to be able to jump up, start asking questions yourself, but you can slip notes to the attorney. And you know, sometimes it's tough. I mean, you feel like you're a juggler when you're in that courtroom and you're trying a case, and it's good if you get somebody that can kind of keep those balls organized and start feeding them to you one by one, you know. So very good. Well, if you want to look at your book, look at pages 280 and 281. That'll give you some interesting reading on hot issues, and so it can be very helpful. There's a short summary there that could also be helpful. You know, when you're doing these summaries yourself of deposition, very important to do what the attorney wants you to do. And here again, with experience, you develop a really good, almost unspoken relationship where you know exactly what they're looking for and you know where to find it in the deposition so you can get it well organized. The whole point of it is boil that 50-page deposition or even longer down into a more manageable, you know, 10 pages maybe, or even less, maybe 8 pages that the attorney can read through, find what he's looking for. Very important to say page 8, line 2, so that when he's in the courtroom and he has the witness looking at his deposition, he can take him right to it. The judge will have his copy, the opposing attorney will have his copy, and so you can make it run smoothly, go right to the part you're looking for using that summary. It's very excellent and a good way to go. One last thing I've touched on before is written depositions. These are quite rare in Indiana, almost never seen, because here again the person has an opportunity to think about the question and develop an answer, kind of the way you would take an essay test, you know, where you've got time in an open book test to look things up, think about it, you know, whereas the standard deposition, you got to be on your toes and they're calling for an answer like right now. So look at Rule 31 if you're interested in the written questions. Also keep in mind that the Indiana rules and the federal rules are not the same in some areas on time limitations on depositions in general. So keep that in mind, very important, because you can get yourself in trouble with the feds if you're trying to go by a state time frame and they have a much shorter schedule in federal court. So keep that in mind. Enjoy. Hopefully you got something out of this, and I'll be back with you with another litigation lecture in the future. Thanks for watching.